morning. It's great to have you here. On behalf of Dean Lavi Dessen and Associate Dean and Director of the Center for the Study of Dispute Resolution, Bob Bailey, I want to welcome each one of you to the University of Missouri School of Law and to our annual Dispute Resolution Symposium. Every year we here at the law school look forward with excitement to the opportunity that this event brings us, the opportunity to meet some new friends, to visit with old friends, and equally important, to listen to leading scholars in the field talk about cutting-edge issues in the field of dispute resolution. And this is certainly the case this year. The issue that Professor Rubin has identified, the relationship between ADR and the rule of law, is clearly an issue of extreme importance to lawyers who on a daily basis have to live in both the world of dispute resolution and the world of the rule of law. Not only has Professor Rubin identified a critically important issue, but he also has assembled a first-class lineup of scholars and practitioners. We thank Professor Rubin for having taken the lead in organizing this year's program, and we thank each of you, the participants, for making his vision for this year's symposium a reality. So to all of you again, welcome. If there is anything we can do here at the law school to make your time here both productive and enjoyable, please let us know. We look forward to listening to you, your presentation, and thank you in advance for what I know will be an exciting and enriching day. Thank you.
All right. Well, this is exciting, and I'm really glad there are so many people here. We do have a wonderful day ahead of us. I want to begin, though, with a few thanks. First of all, to all of our panelists who travel not only from the East Coast but the West Coast, and not only domestically, but we've got a couple of panelists who are going to be Skyped in, for lack of a better term, from India and from Israel. So this is truly going to be an international event. That's appropriate because we really haven't had a serious discussion about the relationship between ADR and the rule of law, and that may be a little bit surprising to most of us. But the fact of the matter is, the issue really hasn't been engaged. There have been a couple of pieces that sort of scratched the surface of it, or at least in the legal literature, that scratched the surface of it. One by my former colleague here, Gene Sternlight, one by my former student here, Cynthia Alcon, now a professor at Texas Wesleyan, and they, I think, alerted us to the need to look deeper on this issue. So I want to thank everyone for participating and acknowledge the initial contributions that they made. I also want to thank our co-sponsors. I really can't use that word exactly, but those who are participating with us in the presentation of this. That includes the American Bar Association section of dispute resolution, represented here by its chair this year, Wayne Thorpe, who came in from Atlanta. And I also want to thank myself, the Missouri Center for the Study of Conflict Law and Media, which is also co-sponsoring this. Let's see, just a couple of where we're going to set this up as a substantive matter. First of all, I really am thankful for all the students who are here. I doubt it seriously, but if there is anyone who's going to have to leave right at 9:15 because of another class and we're not quite done, if you think that might be you, kind of move your way over to this side of the room. And for our participants, you should know that we may have students coming and going today. Let's not let that disrupt us. They've got classes. We all know how that works. The other thing is, for participants, if we can keep our remarks tight, I have suggested 15 minutes. We have one of the toughest guys in the school as our timekeeper, Ben Arullo. Anybody who knows Ben knows that he can be very unnice about these things. So. But he will flag you. He will flag you. Again, I want to just say that that my hope is here that we can have a meaningful discussion about this. Now, there has been some consideration of this issue, but it's really been tangential, and it's been in the form of what I call the rule of law critique. Scott, if we can have the overhead, that would be great. It comes in the form of what I call the rule of law critique. Very early in the history of the ADR movement, as you can see on the slide, very early in the history of the ADR movement, there was an important critique by a Yale law professor, Owen Fisk, in which he said he was against settlement. And you say, how can he be against settlement? He was, and is, indeed against settlement. And the concern that he had, and he articulated this in a series of concerns, was first about the power imbalances that exist in disputes, that exist in conflict. He was concerned about consent issues, what he called affirmative consent, whether in say representative context, the represented party was really consenting to what was going on. He recognized, for example, in say desegregation cases, big public policy cases, that sometimes courts need to have a continuing role in order to make the rules work, even in a situation where you've got consent decrees. So he lays this out in this article against settlement, one of the early critiques of dispute resolution in the field. And as you can see, this really resonates with the rule of law. I mean, it really is about an appreciation that in our society, legal rules that we use to order conflict. And his concern is that if we don't use those, people are ultimately going to be hurt, disadvantaged, and that's the reason that we have those rules in place. David Lubin, another early scholar in this field, a critic, again gave us another what I call a rule of law critique, and that is the concern that if we don't have that we have a lot of settlement, if we use ADR, that we won't have decisions by courts that will guide future behavior. In other words, we'll lose the public education benefit of the rule of law. And again, it's an important critique. Finally, Laura Nader, yes, Cicero Bell, an anthropologist at Berkeley, raised the so-called harmony critique, and that is that what settlement, what ADR will ultimately do is really just foster harmony to the denigration of the rights that people have. In other words, that ADR will be used to subjugate people's rights, to deny them rights, and rather simply will make them happy with their situation. And again, all of these can really be thought of as critiques from the rule of law, from this idea that the rule of law exists to provide order for our society. And so it really raises the question for us, well, are they right? These critiques were some time ago, and we've seen during the course of the unfolding of the dispute resolution movement, not just here in the United States, but internationally, we've seen a lot of success. And so the question really for us comes quite clearly. I mean, is ADR in tension with the rule of law? Or in some way, can they work together? Can they complement each other? And this is the question that really has not been explored yet. And so this is why we are here now. We're particularly fortunate today to have a keynote presentation by Tom Tyler and Rebecca Hollander Blumoff. Rebecca's actually been presenting the paper, thankfully. Tom unfortunately could not make it to this last minute conflict that was simply unavoidable. But they'll be speaking to us from the perspective of procedural justice. Now, some of you here may already be familiar with procedural justice, and Rebecca's going to explain a lot more about it in just a few minutes. But the central idea behind procedural justice
wonderful place to talk about dispute resolution. You all have such an amazing commitment to that as a field of study. It's just wonderful to be here again. So I want to start by asking, what are key questions for all dispute resolution mechanisms? Well, the key questions are, will people be satisfied with the resolution that's reached? Will people adhere to the resolution that's reached? And then, once we have all that said, are the resolutions consistent with the basic values that we hold in our society or in any given society where these resolutions are taking place? How can we answer these questions? Well, to kind of give a little preview, procedural justice, it's a great answer to these questions. Procedural justice plays a really important role in guiding people's perceptions about resolutions and also in keeping resolutions in harmony with basic values in society. So I'm going to start in this talk today by explaining procedural justice. I'm going to move from there to talking a little bit about the procedural justice rule of law connection. And I'm going to conclude by offering some thoughts about how this relates to AZR and some questions moving forward, given those connections. Okay, so what is procedural justice? Well, procedural justice is a subjective assessment by participants in a dispute resolution system about the fairness of the process by which a decision is reached at a time. So what isn't procedural justice? It's not distributive justice. That's about the fairness of the outcome. It's not outcome favorability. That's about how good the outcome is. Procedural justice, again, is the assessment of the fairness of the procedures and the process that's used to make the decision. Okay, so a very robust body of research in social psychology has shown that procedural justice drives measures of satisfaction that people have with their outcomes. That procedural justice predicts future experience to outcomes and agreements. And procedural justice has the added benefit. It does reflect values that are basic to our system of government. So what is procedural justice? Where does it come from? How do people form their assessments about the treatment that they're getting? So in procedural justice, researchers have explored what are the antecedent conditions for people going through the treatment. There are four kind of big ticket items that researchers have come up with to explain what drives people's fairness judgments. The first thing is, did people have a voice? Did people have the opportunity to be heard, to present their case, to feel that they've been listened to? The second thing is, was the deciding party neutral? Was the decision based on some set of rules that were transparent, that were visible? The decision wasn't based on something besides the rules, something hidden. It's a neutral decision, right? A neutral decision maker. The next item is related to neutrality, but distinct. Trust in the decision maker. Do people trust the person who is giving the decision? Obviously, it's hard to trust somebody who's manifestly not neutral, who's biased, but also trust relates just slightly more distinctly to the idea that you can trust the person's motive, that the person is motivated positively, the person doesn't have a negative motive in their decision making. And finally, procedural justice has identified being treated with courtesy and respect as another fundamental underpinning of people's assessments of whether the procedure was fair. Okay, so those are the four kind of pillars of procedural justice research and the antecedents of procedural justice. Where do we find procedural justice effect? Where does this make a difference? Okay, the original research was in formal legal settings, like court, right? Lots of rules and decision-making, third-party, formal structure. And there was a lot of research done in that setting that showed that people cared about the procedural justice of the decision maker. Even when people just to be clear, some of you might be thinking, well, defendant in a felony case, I bet they really cared about their outcomes. People care about their outcomes in all of these settings. Okay? Procedural justice doesn't suggest in any way that people don't care about either the distributive justice of their outcomes, that is their fairness, or the outcome favorability. What procedural justice suggests is that there's a separate, independent construct of how fairly people feel the process treated them that has a separate and independent effect apart from how good the outcome was or how fair the outcome was. So fairness of outcome, goodness of outcome, I don't want you to leave the she said that didn't matter. It matters. It matters. But an independent driver of satisfaction with agreements and adherence to them is the fairness of treatment. Okay. So after this more formal research has got kind of excited about this, how far can we extend this? Where are procedural justice effects besides this formal spiritual setting? And research has turned their attention to other settings like mediation and negotiation. So in each of these areas, procedural justice researchers have found that procedural justice drives assessment about satisfaction with and adherence to. So, for example, Pruitt did an amazing study with a number of colleagues where he looked at a mediation. He looked at that mediation at the time of mediation, got people's assessments of what happened in the mediation, how good the outcome was, how fair the outcome was, how fair the process was. 6 months later, the biggest driver of whether parties were still adhering to that mediated outcome was the procedural fairness of the treatment received in the mediation, rather than the outcome favorability or the fairness of the outcome. In my own research, I look at negotiation, and I found that fairness of process, fairness of treatment by the other party in negotiation, even without a third party neutral, drives people's satisfaction with the outcome and it drives how enthusiastic they are about adhering to the agreement and recommending to their client that their client accept the agreement. Okay, so what are the theories for why procedural justice matters? Now that we've established this robust body of research that shows that it does, why? Why do people care? There are 3 big theories for why people care about procedural justice. The first theory is the original theory that Thibault and Walker, who are kind of the founders of procedural justice, put forward. And their theory was people care about fairness of process because it tells them whether they're getting a good decision or not. That's what is going to give them a good decision. They know that if the process is fair, they're going to do well. And that's why people care. This is called the instrumental theory because it's purely instrumental. People only care about outcome and the fair process is the key direct outcome. So that was the first theory. Tom Tyler and Adam Lynn came along a while later, and they proposed something called the group engagement model. And what the group engagement model suggested is it's not instrumental. People don't care about the fairness of treatment because it leads them to get them a better outcome. They care about the fairness of treatment because fairness of treatment tells them something about their status within the group. It gives them some sense that they are valued members of a particular group, that they have some status within the group. This in turn affects their self-esteem, their sense of self-worth, and their social identity. And so the group engagement model is a very different way of thinking about why fair treatment matters. And Tyler and Lynn did a number of studies where they showed that that was really dominant to the instrumental model. More recently, Vandenbos and Lynn have suggested another way of thinking about fairness of treatment and why people might care about it. That's very much in keeping with the cognitive bias literature that's really been developing very strongly in social psychology. And they suggest, it's really hard to know whether you have a good outcome or a fair outcome. Those of you who've taken a negotiation class, know that when you come back into the room, you can write on the board, 10 different outcomes, everybody negotiated the same problem. Well, real life's not like that. Everybody has an outcome that's a little different. Everybody has a dispute that's different. How can you possibly say, well, I know just how I did in comparison to everybody else? You can't. So sometimes we just don't know. We have a vacuum of information. And fairness heuristic theory suggests that people use the fairness of the treatment that they receive as a proxy for how good the outcome is. That they infer from how fairly they were treated by that party how well they negotiated. Okay, so what does this all have to do with legitimacy? Well, take a step back. Why do people defer to courts to make their decision? And we do that when we feel that the decision-making authority is legitimate. Why do we really care about this? Well, psychological research has repeatedly shown that people follow rules when they believe that the authorities that promulgated the rules are legitimate. Now, when do people feel that authorities are legitimate? Tom Tyler's research, along with others, has repeatedly shown that people feel that authorities act legitimately when they have experienced procedural justice violations. Okay, so again, just to kind of link this back up, this means that in a situation where someone feels that a decision maker is neutral, is trustworthy, that they have been given an opportunity for voice, and that they have been treated with courtesy and respect, they are likely to feel that that is a procedurally just decision-making process, and that that decision maker has legitimate authority, and that they ought to defer to that decision maker. Okay, so key point, just to remind everyone, people's assessment of how good or even how fair their outcome is in a particular setting is not unimportant, but it is not the only driver of whether they are satisfied. And in fact, research repeatedly shows it's not the most important driver. In this research, procedural justice consistently trumps people's assessment of how good the outcome was, how fair the outcome was. Let me put that on. I got the timer. Does that mean I have 15 minutes left? Or I talked for 15 minutes? Okay, thank you. Good to know. Like I have to do some subtraction here. That's kind of complicated for early in the morning. Okay, so as I said, people's assessment about how they're treated affects legitimacy. Okay, it drives legitimacy. So good outcome, fair outcome, not as compelling in driving legitimacy judgments as procedural justice. So Curators found this effect in settings as diverse as in court with the judge and in the workplace with the manager. When individuals feel that authorities are making decisions in particularly fair ways, they believe the authority is more legitimate, and they're more willing to defer to the authority's decision. So what this means is we need less command and control, and we can rely more on self-regulation in settings where we can have an authority acting in a procedurally fair way. So Curators done some really interesting research that asks, is the judgment about legitimacy largely resource-based, or is it more relational? That is, do people make judgments about legitimacy based on treatment that they expect to provide them with more resources, or do they make these decisions based on treatment that affects their social identity? And he has repeatedly found that legitimacy and deference to authority are fueled by relational factors. People voluntarily defer because their treatment suggests that they have status within the group, and they are therefore willing to defer to authorities. In one study that he did, he found that the relational dominated the instrumental in terms of effect. In regression analysis, there's a thing called beta weights. They suggest the relative importance of effect, and the beta weight of the relational is 0.5, the beta weight of the instrumental is 0.2. That means we have over twice the effect for the relational that we have for the instrumental in terms of the analysis of various factors effect on legitimacy. Okay. So again, the basic framework, certain factors influence judgments about fair process. Fair process leads to perceptions of legitimacy, and that in turn produces deference to and adherence to judgment. Okay, so great, that's procedural justice. What does this have to do with the rule of law? Let me just get into the rule of law. Well, what do procedural justice and the rule of law have in common, and how do they differ? Okay, so starting from the point of origin, they're quite different, right? Let me start there. The rule of law developed as a protection against tyranny by government. Procedural justice is about subjective perceptions of fairness by individuals. So that's pretty far apart, right? But that difference right there shows actually how much the two concepts have in common. The design of the system of law to protect individuals from tyranny is in fact what provides us with our template for what fair process looks like. So in some ways you could say the foundational concept of rule of law is what gives us the capability to make individual determinations about what behavior is fair by our lawmakers. Another difference that I want to talk about, procedural justice is expressly not about substantive rule application, right? Remember what I said, it's about subjective perceptions of fairness of process, not about substantive outcome, right? So procedural justice other thing that rule of law and procedural justice have in common is they both directly address what factors lead to perceptions about legitimacy. What makes people believe the law is legitimate? A lot of people, if you ask them that, the rule of law, right? Anytime you read about things with the rule of law, you can hear rule of law gives government legitimacy, rule of law, not men, that makes government legitimate, right? And I've just told you, procedural justice also means legitimacy. Okay, so you might be saying, what does everything mean by rule of law? That's a good question to put right about now, right? Good question. Boy, there's a lot of debate about what the rule of law is out there. If you Google it, if you go on Westlaw, I mean, it's like an onslaught, right? What is rule of law? There is more debate about that than I could possibly summarize here, and I really am looking forward to hearing how all of you throughout the day conceptualize rule of law. The very thinnest description of rule of law, as my colleague Brian Nava has written, requires government actors and citizens to be bound by and act consistently with the law. That's the thinnest. And then it leads to the idea that law has to be set out in advance, be general, be clear, stable, and applied to everyone. And then from there you can make much thicker descriptions of the rule of law. A few more detailed clusters of elements of the rule of law that Tyler has used in some of his empirical work include rule-based decision-making, that is evidence-based, fact-based, consistent, and transparent, respect for rights and legal principles, and respect for persons with dignity. So those values kind of map nicely onto the construct of procedural justice in psychology. For example, evidence-based means that somehow people's case has to get before the decision maker, right? So that relates pretty nicely to voice. You have to have an opportunity to present your case. Evidence-based, fact-based, consistent, transparent, neutral, respect for legal principles, those all relate to that trustworthy and neutrality of the decision maker. Respect for persons with dignity pretty nicely maps onto courteous and respectful treatment. You don't really hear a lot about courteous and respectful treatment in the rule of law literature, but you can hear about dignity. Things are obviously connected. So I want to amplify just for a couple minutes these areas of connection and disconnection. There are two categories of procedural justice factors. Some are decision-making based and some are relational based. Right? Trust, first respect can be more relational based. Neutrality and voice are more decision-making based. Although voice you can kind of argue goes in both categories. The rule of law factors tend to fit best with the decision-making factors. The relational factors are slightly less obviously connected to most of the rule of law values. On the other hand, the entire function in some ways of having a rule of law is to make sure that people are treated dignity in society, right? Why do we care about tyranny of government? Because we care about people being treated with dignity. So just as this is one possible reason for the importance of procedural justice, that people care about their relationship, their status, their social identity, so too you could suggest that the entire rule of law really has as an underpinning how we treat individuals in society. Again, rule of law doesn't have an express component for voice, right? But as I said, in our system, the rule of law takes the form of opportunity for facilitating that. You could imagine a system, say an inquisitorial system, where people's evidence is presented through an inquisitorial model judge rather than individual parties as we have in the adversary system. But in our system, the rule of law takes that form, so we have this mapping on of the procedural justice. Okay, so Tyler's done some research using factors related expressly to rule of law judgments versus procedural justice judgments. And I want to talk a little bit about some of those findings. What he has suggested in some research that he did with Woe in 2002 is that there's a two-stage model where elements of rule of law shape judgments about procedural justice and trust, and that this in turn then influences willingness to defer to the court. Again, back to legitimacy. So what he found in that study was procedural justice, trust, and outcome together explain 82% of the variance, 82% of the difference, right, in deference to judicial decisions. But the procedural justice and trust alone explains 79% of the variance. Okay, so that means 82% when you include outcome, but 79% when you outcome is not the driver here of people's separate concept. That's the driver of people's separate decision. Similarly, in encounters with the police, what Tyler found was procedural justice, trust, and outcome together explain 85% of variance for deference to police. But procedural justice and trust alone explain 84%. It's only 1% that was taken out when you took out outcome, right? Again, so outcome not fueling these decisions about deference to authority. Using that same data, Tyler identified particular factors that were more related to the rule of law per se. So rule-based decision making, he asked things like, did the authority allow a story to be told? Did the authority make neutral decisions? Were there consistently applied rules? And did the authority act transparently? Other rule of law elements, respect for rights. Did the authority make decisions consistent with the law? Did they acknowledge and show concern for people's rights? And lastly, respect for persons involving treating people with respect personally. Okay, so what he found there was that in terms of taking the rule of law factors and outcome together, that accounted for 73% of the variance in procedural justice judgment, 79% of the variance in trust, and 81% of the variance in deference. When you took outcome out and you were just looking at the rule of law factors alone and their influence, that was 73% for procedural justice. That is the same as with outcome. 78%, that is 1% less for trust, and 80%, which is 1% less for deference, right? So again, we're seeing a lot of impact with the law and not a lot of impact with outcome at all. Okay? And there were similar findings for police encounters. So the factors that were driving decisions about deference to authority were rule of law factors, right? So basically what this research suggested was the ability of courts and police to gain acceptance for their decisions was dependent upon judgments that courts and police were acting in ways that were consistent with the law. Okay, in another study, I don't know if I'm arguing with statistics, but it was just another study, Tyler found that 65% of the variance in trust was explained by rule of law factors of rule-based decision-making, respect for rights, and respect for persons. Performance mattered, but it was not the primary driver. So again, the rule of law factor was a big difference for people. Okay, so empirical data shows that individuals perceive decisions as legitimate when they're provided with procedural justice. And to the extent that the contrasts are similar and sometimes overlapping, also people perceive decisions as legitimate and defer to them to the extent that they embody these rule of law values. Okay, so we have some overlap and some empirical data that shows these things are both connected, that rule of law values include procedural justice and deference to authority. Okay, so what are the implications for PDR? Aren't we mostly talking about procedural justice, as I just said, in a third-party decision-maker context? First of all, no, we're not, right? No, we're not. Arbitration, of course, is very similar structurally to litigation. Mediation has a third-party neutral, non-binding authority, and negotiation has no authority. Can we really talk about procedural justice in all these settings? I would answer an emphatic yes. We have significant findings for procedural justice in all of these ADR settings, distinct though each of them may be from each other, each one structurally different. We find procedural justice effects for all of them. When we look at the antecedent factors for procedural justice, that is voice, trust, neutrality, courtesy, and respect, they're perfectly applicable in all settings. They're just applicable a little differently, right? So when you think about voice, trust, neutrality, courtesy, and respect in arbitration, it looks a lot like those factors within litigation, right? When you think about mediation, in contrast, we're really probably most interested in the voice opportunities, and that's what the literature suggests. We're really excited about the voice opportunities in mediation. But we still care about neutrality and trust of the third-party neutral. Even though they're not a binding decision maker, we don't want them to be biased. We want them to be trustworthy. But maybe our focus moves a little bit to valuing voice over those other factors because they're more important in that setting. And then in negotiation, the jury is out a little bit on whether neutrality matters. You can imagine in a bipartisan system that we have with two devil's advocates negotiating, it's sort of hard to imagine one of them being neutral, right, and bias-free. That's kind of a job to represent a client. So neutrality, the data is mixed, but with respect to trust, courtesy and respect, and voice, those all are things that drive people's acceptance about fairness process and relationship and fairness process in so the concern about the rule of law in VR, I think Richard has done a very nice job of highlighting, and I know we'll hear more about all of that through this draft today, and Sternlight has done that in earlier work, and of course Owen Fisk kind of got that ball rolling, suggesting a tension between APR and the rule of law from a substantive perspective. But if you actually look at the particular dispute resolution mechanisms, you kind of see a little bit different picture emerge, I think. So I want to start with arbitration. I haven't gotten my friendly timekeeper message in a while, so I'm assuming I'm okay. So I want to start with arbitration, right? So arbitration looks a lot, as I said, like litigation. So we might think about arbitration very much kind of mapping onto our procedural justice concerns and our rule of law concerns that we have about litigation. But arbitration is supposed to be faster. It's supposed to be more efficient. And so we remove some of our procedural protections, right? And that's a real concern that commentators of arbitration have. If you think about a case like Gilmer, where the court denied special procedural protections that we have in our litigation context for arbitration, we have a system now where we have a lot of the worrisome things about litigation maybe without some of the procedural benefits that we get. Now there are outer limits to that. I'm sure some of you are familiar with the Curators case in the Fourth Circuit, where you're going to say, wait a minute, you can go too far. What was too far for arbitration? A non-neutral arbitration panel, right? So getting right back to our factors that we are concerned about, a non-neutral arbitrator, not okay, right? So there are limits to what we allow, but not that many, right? And why is that? Because commentators suggest, pro-arbitration commentators, this is a market process and people will not choose it if it's manifestly unfair, right? So, the opposite side of that is, right, that there are external pressures and power differentials that influence when people engage in arbitration and when they don't. So this suggests perhaps more need for judicial oversight in the arbitration process, and suggests maybe that we ought to think about caring more in arbitration about both the rule of law and procedural justice. In mediation is tough, right? Right now we have a real spectrum of the way that mediation is presenting itself. And Welch in particular has written about kind of the thinning vision of self-determination in mediation. Right? Mediation used to look more voice-driven, more self-deterministic, and now with court annex mediation, we're having less and less of that. It's looking more and more like another kind of litigation, right, where a mediator gives you not a binding decision, but kind of a guiding decision, right? So how does this relate to the rule of law? Well, if you think about this narrow vision of mediation, maybe we shouldn't worry that much if we care a lot about the rule of law, because the mediator is given the rule of law, right? The mediator, if they're neutral and unbiased, it's just a nice, pass-through for the rule. It's rule-based decision-making rather than interest-based decision-making. But on the other hand, you lose some of the real self-determination benefit of mediation when you do this from an ADR theorist perspective, right? And so procedural justice as a framework implies that the shift in focus away from the rules has a concomitant benefit because it increases voice, trust, and courtesy and respect, even though you're losing maybe a little bit in the neutral decision-maker. So the situation here is that both court annex mediation and kind of our more traditional vision of mediation, they both have the potential to satisfy procedural justice needs, but the impact is different on different procedural justice factors. So we really have to think about which procedural justice factors are most at play here. If you go into a mediation and you expect voice to be the paramount thing, and you don't get it, you get something more like litigation light, it might still match your procedural justice concerns if you knew that's what you were getting. So we have a question of expectations matching reality. Okay. Finally, negotiation. I already talked a little bit about the neutrality thing, and we might worry about that, and we might also worry about people not trusting other parties in negotiation. But there's lots of potential for voice in negotiation. There's certainly potential for some respect, although we don't always see that. How is rule of law relevant at all in the negotiation? Right? And Newton and Kornhauser suggested that we bargain in the shadow of the law. So for those those of you who like the idea that legal endowments, if you look at what happened in a negotiation, great, maybe we're done, right? We've got the rule of law, because the rule of law that's just what people do, because that's what the law is. I think, at least in this room, we're all pretty confident that that's just not what happened. That's just not the description of what actually happens in negotiation, and that you can't really say in any meaningful way that negotiation is a strict rule of law process in a substantive law sense. We have the most self-determination and ability to craft solutions here that don't match at all what the substantive endowments of the law are. But even in negotiation, we find procedural justice effects, right? We find these procedural justice effects. We find that people care about their voice, and they care about trust, and they care about being treated with courtesy and respect. Okay, so all of these processes share that individuals care about their process. And research has suggested that when people are thinking about evaluating institutions, they focus mostly on values like neutrality. And when they're evaluating other people, they're much less focused on neutrality and much more focused on things like treatment and trust, the relational variables. Right? So again, fairness of process, how people define fairness of process in any given setting may really tap into slightly different constructs. Right? The less formal the process, the more focused on treatment and trust, and the less focused on neutrality and motivation. So different emphasis on different rule of law elements in different processes. Right? So the sliding scale of procedural justice factors importance may depend on the setting. These four factors that I mentioned earlier, they're not kind of automatic, you put it in on one end and it spits out on the other how fair it is. It depends on the context and who you're dealing with and what you're expecting from that particular decision-making mechanism. Okay, so the takeaway on this is that rule of law elements matter to people even in non-judicial decision-making settings. Rule of law elements matter to people in ADR settings. Now, we know that many people like ADR, many people choose ADR, so can we trust them to vote with their feet? And that is to say, what makes ADR popular is it responds to people's concerns, and so, since we have a lot of research showing that people like ADR processes, they choose ADR processes, and they rate them highly, especially when they think that they are going to provide their treatment, although Hensler's research is a little bit recovered with that, so the jury is out a little bit on those questions. But as a basic premise, I think people do tend to pick processes that they think are fair. So we could say, as kind of our protection, well, people won't engage in ADR if they don't think it's going to be fair. And since we know that the procedural justice assessment drives people, and maybe there's enough parts of the rule of law and procedural justice, then maybe we can say, since that's the driver of decision acceptance and satisfaction, people just won't choose it if they don't get a rule of law blow out of it. So the market's going to take care of this. ADR is mostly pretty entered into, so not a problem. Now, in some of the international contexts, we might hear some different stories, and hopefully we'll hear more about that later in the day. So to the extent that people's procedural justice needs are met in ADR, you might say that the processes are occurring under the shadow of the rule of law. And I'm listening sometimes. They're occurring in the shadow of the rule of law. I would say that to the extent that this is happening, that's not a really accurate description. I would argue the rule of law really embodies what we want in dispute resolution. Right? And so even though we enshrine it in our formal settings and not in our informal settings, we're still looking for it anytime we have decisions to make. That's what we're looking for. That's what we want. Indeed, there's even research that Tyler has done with Harris Sondex non-rule-based decision-making systems in order to further people's perceptions that they can be treated fairly in accordance with procedural justice principles, and therefore to further the aims of the rule of law and legitimate governance. And that is the question that I leave you with, and I look forward to hearing more from everyone throughout the day. Thank you very much. I forgot that you could ask me questions.
Not to talk loud to get over the din, but
I guess my question has to do with homogeneity versus heterogeneity of people's reactions to procedural justice. Tyler seems to be treating people as all of one kind of skills. I know another person on your dissertation committee, John Mills, seems to think that there are people who conceptualize authority very differently, although it's not really clear to me whether that conceptualization is about social authority as opposed to the kinds of authority people interact with in their daily lives. What I'm wondering is, are there any implications for the kind of work that Joseph does in terms of heterogeneity of people's reactions to procedural justice?
Right, so this is a great question, and I actually had a little note in here about that. So what's interesting there is that Tyler's work suggests that these procedural justice judgments happen across the board, right? All kinds of cultural, ethnic groups have this, minority, majority, different ethnicities, all have the same way of assessing fairness of process and the same impact of fairness of process. Right? What's different, he finds, is in terms of the legitimacy of that people's social identity is more kind of on the hot seat, you might say, when the group that's making the decisions is a group that they feel that they are part of. Right? So their treatment by the authority group is more important to them in terms of the legitimacy of that authority when that group matches they feel that they're a member of that group. So an out-group person looking at an authority system of an in-group, not as meaningful to them in terms of legitimacy. Now, how does that relate to Joe's work? I mean, that's an interesting question because Joe suggests that the system justification theory that people have ways of thinking about legitimacy even out-group, right? Even for the groups that they're not part of. And what I think is most interesting there is that Joe's work really taps into Tyler's work in the sense that system justification theory, for those of you who don't know what it is, it's the idea that even disadvantaged groups will justify systems of power and authority when they don't get the resources that other members of those groups get. And what's interesting about that is that it really suggests just how relational this all is and just how non-resource driven it is, right? Because if these things were resource driven, if we thought about legitimacy of systems based on resource allocation, we would just not find this. We would not find system justification effects. We wouldn't find disadvantaged people justifying the legitimacy of our systems.
any other questions before we move on? Yeah, Stephanie.
Has any of this research been done in the global south versus only U.S. and Western?
There's been procedural justice research done about in Asia. I'm not sure if you said the South.
Well, or outside of the U.S.
Yeah, there have been cross-cultural studies. What typical effects are that procedural justice matters, but procedural justice elements are defined differently in different cultures, right? So you might imagine, cultures that have less interest in voice. I believe there was a study even in Florida where they looked at Hispanic and non-Hispanic, and they looked at this in the family context of procedural justice. In a Hispanic family, there wasn't really an expectation of voice the way there was in white families. So that wasn't part of the procedural justice assessment that people made because it just wasn't cultural.
Yeah, go.
This was a terrific presentation, and I'm so
I'd like to believe it too.
Your last one, right over here.
Throughout the presentation, I think I heard you correctly. You used the following terms, somewhat interchangeably: difference to authority, legitimacy, acceptance of outcome, and protection of the fairness of the process. And those to me sound like very different things, you know?
Those are different. I would say deference to authority and legitimacy are kind of largely conceptualized as the same in this literature. So when you have deference to authority, it's because of legitimacy. It's not rule following because of command and control. It's a deference. Voluntary deference suggests legitimacy. The other two, I would say, are different. And to the extent that I mushed them all together, my apologies.
No, I just trying to say sort of what, I guess, the question, what is legitimacy then? Is it just that you feel good about the outcome, or is that you respect the outcome and you're not going to revolt about the outcome? How are you trying to score for this?
Yeah, I mean, I think the way that legitimacy is really constructed in this literature is that it is kind of the same concept as voluntary deference. Now, voluntary deference is not the same as procedural justice. Procedural justice fuels the deference. You can have deference without procedural justice. People might differ anyway. But in this literature, procedural justice is found repeatedly to be a primary driver of the voluntary deference, which is conceptualized as legitimacy. And then there was a fourth thing, and what was that, trust?
Well, perception of fairness.
Perception of fairness. Right? Perception of fairness is the procedural justice test, and the procedural justice judgment is,
Great. I think at this point we'll go ahead and move on and thank Rebecca for fabulous presentation. All right. Let's see. We're going to go ahead and move right along here to our first quote panel, which may incorporate some of these things. I don't really know. But it's kind of a special panel that we're really fortunate to have people who have been doing and been involved in U.S. policy with respect to the rule of law for many years now. And so when it comes to the rule of law for them, this is not a matter of theory, but rather this is a matter of practice and what's been driving U.S. policy in this regard, what works on the ground, and so we asked them to bring their experience and insight to this question of how ADR fits into this rule of law. Our first presenter is with the Ambassador Jim Michael, who spent many years with the USAID, and I'll just call her rule of law point person. Is that a fair statement? He has an extensive history, and on this, the White House asked him to come back. Obama administration asked him to come back to help them. He's been there for the last, came out of retirement to do this, has just left the government again, and is now going to be doing some of the work that he enjoys doing the most. So he'll be our first speaker. Our second speaker is going to be his good friend, Bill Davis, who is a co-founder of the San Francisco firm called PPK Consulting. And they actually have been working for more than 20 years in terms of actually implementing, or I should say designing and then implementing rule of law initiatives around the world. And so Bill's going to talk a little bit about that, how it's worked, how EDRs fit in, hasn't worked, et cetera. So very fortunate to have these people who have actually been dealing with this on the ground. First, Ambassador Jim Michael.
Thanks very much. And Richard, I want to thank you and the university for organizing this symposium today. I think it's really an interesting
going to have a brief technical interlude right now, technology interlude. So we'll have, just kind of imagine in your mind some background music.
I call it slide.
Kind of stretch a little bit. Welcome, Lisa. Glad you made it. I got it.
Technology is wonderful. Okay, I think we are in business. Sorry about that delay. Let me start by just observing that there is increasing interest in alternatives to litigation as a way to strengthen the rule of law and to expand access to justice in developing countries. And the principal question in this context is how
Archiving started.
procedures that meet those expectations of respect and trust, voice, that are timely, inexpensive, and understandable to people, expand their rights and opportunities, and especially for poor people who otherwise may not benefit in their daily lives from the protection of law, the invisible people who make up the majority in many countries. I want to talk about three things: the concept of development and international cooperation, how the rule of law relates to development, and how ADR relates to the rule of law. First of all, what is development? There are lots of definitions, and first of all, you can see it's important. Second, I like this definition of a process that enables societies to help societies be stable, just, and prosperous, and people to benefit. So, among the points of convergence about what is development is the notion that development is ultimately about people, their ability to experience security of person and property, to earn a livelihood, and to exercise legal and political rights. The second point of convergence is that development is a long-term and a complex process that has lots of factors: economic factors, social factors, political, environmental, security, and they all happen at the same time, and so you have to pay attention to all of them. Then a third point, that development comes from within a society, from the interaction of political leaders, from public and private institutions, and civil society. External assistance can help, but it cannot replace local initiative. Now, the practice of international development cooperation to support development has seen substantial departures from these recognized concepts and sound policies over the years. International actors sometimes get attracted to silver bullet solutions, what is known as flavor of the month approaches to development. And so you'll get, if only we had better infrastructure, if only we had better policies, if only we had education for all, if only we had microcredit, that would solve it all. And also, donors sometimes try to impose their own agendas, what they think is the right way for development to occur, rather than analyze and support local commitments and priorities and capacities that cause development to happen from within. Now, worldwide fiscal pressures are casting a shadow of uncertainty right now. We don't know where Europe and the United States and the other major donors are going. But there are some recent trends that hold promise, I think, for better aligning the practice of development cooperation with what we know to be sound approaches. First of all, there are new actors. China, Brazil, Korea. They have a different perspective about development cooperation. There are new organizations like the G20. There's the weight of the private foundations like Gates who come in. They have a lot of knowledge. They have a lot of resources. And you have workers' remittances. You have private investment. Finance for development is changing dramatically. So that's expanding voice, I think, in the process of development cooperation. Second, there are new international standards and review mechanisms that are holding the international community more accountable. The 8 Millennium Development Goals are focusing efforts on poverty, education, gender equality, health, environmental sustainability, and on addressing those issues through partnership. The internationally agreed principles of aid effectiveness, like the Millennium Development Goals, are monitored and periodically reviewed, and that process keeps attention focused on these concepts of local ownership, alignment, harmonization, managing for results, mutual accountability as ways to make development cooperation more effective. A third positive factor, I think, is that the United States is exercising renewed leadership. President Obama previewed a new U.S. global development policy in May in the National Security Strategy, and then he formally announced that policy last month at the UN Summit to review the Millennium Development Goals, saying at that time that the United States, and I quote, will be a global leader in development cooperation in the 21st century, something that was rather welcome in that forum. Now, there is no single path to development. There's no formula that can claim universal application. Circumstances differ widely, but research and experience strongly suggest that there are some factors that are pretty constant. And among these is the quality of institutions as an important factor in explaining why Sierra Leone has a per capita income of $500 and Luxembourg has a per capita income of $50,000. The predominant view is, speaking of institutions, that legal institutions are highly relevant to the distribution of power, the regulation of markets, the mediation of conflict, and the resolution of disputes, and therefore are crucial to sustained development. The emphasis on rule of law in international development has its roots in concerns during the 1980s about slow progress in development. This was something that in the United States focused initially on Latin America, where you had political transitions going on, situations of economic difficulty, and the question was, would these shifts from military dictatorship to civilian elected government be sustained? And in Africa, it was concerned about the post-colonial government's capacity to advance economic and social progress in their countries. And the principal development agencies came to embrace good governance as an essential factor in development, and to recognize effective justice institutions as essential for good governance. Looking back, those you say, well, of course, those aren't controversial ideas, but they were at the time. Now, by the time of the 2005 World Summit, the assembled heads of state and government were prepared to agree, and I quote from their resolution winding up the World Summit, that good governance and the rule of law are essential for economic growth, sustained development, and the eradication of poverty and hunger. Something that had been controversial just a few years before was now conventional wisdom. President Obama echoed that same theme in the 2010 summit when he announced the new U.S. development policy and said, we will focus our development efforts on countries that promote good governance and democracy, the rule of law, and equal administration of justice, transparent institutions, strong civil society, and respect for human rights. So there seems to be a lot of consensus on that point. Now, rule of law, definitions. We heard a little bit about that from Rebecca, and here's one that the UN Secretary General put into a report in 2004 that is widely used. USAID has put it into its strategic manual for rule of law, so have a lot of other donors. And it emphasizes that norms intended to be binding should be known and applied equally and fairly to everyone, including the state. Now, over the last 25 years, thousands of reform initiatives have been undertaken to strengthen the rule of law in poor countries. And for the most part, they've involved, to some extent, external financial and technical cooperation. The programs have, in great measure, tried to overcome weaknesses in formal justice systems with a major focus on common complaints by users. And this, Lynn Hammergren did this study with the World Bank a few years ago in putting together their manual for assessing justice systems. Found almost everywhere you find people complain about inadequate access. And that can be for lots of reasons. The courts are too far away. They speak an inherited colonial language rather than the language of the community. It's a different culture. There used to be decision makers who were leaders in the community, and these are people who wear robes and wigs, and we don't know who they are. We don't understand the processes they use. So lack of access. Delay, the courts are crowded, the decisions don't happen. We wait for years and years. We've heard that here too. Corruption, of course, again, the sense of fairness is a big factor in driving people away from the system. Now, many successful reforms can be identified. In the draft paper I've done, I've cited a couple of studies that have tracked some of the real important achievements that have been made in strengthening justice systems. But yet, in many countries, the poor majority continues to rely primarily on informal alternatives to the court. You see estimates for Africa say 80%. I did a study in Zambia where the statistics are not very reliable, but popular estimates are 90% of dispute resolution occurs outside the court. Questions are being raised about what rule of law programs have achieved, about what is the most appropriate emphasis for future investment from the standpoint of development. Is this where you want to put your resources? Is this where you want to put your energy? The Commission on Legal Empowerment of the Poor pursued this line of inquiry a few years ago and recommended a four-part agenda to strengthen access to justice. Assured legal identity for poor people. We have this phenomenon of people who are truly invisible. They have no formal identification, so they can't get their children to school, they can't vote, they are ignored by the law. You have the need for broadened scope of legal services so that people have knowledge of their legal rights and help in enforcing them. You need improved court management so that these complaints about the court are diminished. And you also need, and the fourth point is ADR, informal and customary dispute resolution, complement the formal system. And I must say, I tend to think, rather than think about ADR and the rule of law as being two separate things, I think about rule of law encompassing dispute resolution mechanisms, some of which are more formal than others. And I think it all really can fit together, and you can have better access to justice when you have a broader array of choices for people. And we're seeing more attention to ADR and customary justice systems in justice sector strategies in developing countries. The assessment guides that the World Bank, the United Nations, USAID, and others are publishing now encourage looking beyond the formal system. And it's not an issue of whether informal mechanisms are an alternative, but rather one of the costs and benefits of way to complement formal institutions with informal ones. And access to justice does not mean only access to courts. Now, there's no substitute for our thorough analysis in designing these things. The notions of voice and respect that apply during dispute resolution apply equally in the design of the dispute resolution system. And so, really, a very participatory process to look very thoroughly at the question of what is an effective system really has to provide opportunities What do you do about the people who don't want to change? And how does this all link up the informal and the formal aspects of justice? Then you have to look at what should a justice system be doing? What are the pieces of it? And this is something from the Tilburg Institute, and I've seen similar things elsewhere like this in certain sites. Does your system provide a way to meet, a place to meet, a way to communicate? Does it try to distribute value fairly? Does it have a decision-making procedure? Stabilize, transparency, and compliance. This gets to the enforceability of decisions. And then I add to this the World Justice Report notion of adequate standards of independence, impartiality, fairness, and efficiency. I think those are things you want to look for. Then you have to look at the detailed qualities and characteristics of the existing or proposed local system. And I keep saying the local system because I don't think you come in and say, now, we have an idea of what we do in Missouri, and we're going to take that to Tanzania, and we're going to make it work. But rather look at what's there and what's working and what's not working, and what can be done to make it into a more satisfactory system that will provide access to quality justice. And I won't read all of these, but I will suggest that there are a couple that I really think are important that I've highlighted, maybe not on the slide highlighted, but the links between informal and formal institutions, including with respect to enforcement and appeals and consistency with fundamental rights, and whether the system produces legally significant results. If, we talk about in the shadow of the law, and the Tilburg Institute uses the same language. I think Dean Sternlight uses it also about ADR operating in the shadow of the courts and just formal justice system, setting some standards and rules and protection about how it works. If it is off on its own, I think it's very vulnerable to the kinds of distortions and abuses that have been the subject of some of the critiques. Secondly, does it enjoy the support of the judiciary and the government, accepted by those in leadership positions as well as by the people who are the users of the system? Because we have situations, I can remember in Colombia, for example, when they amended the Constitution to allow ADR, that some of the judges didn't want to enforce those outcomes because they didn't look like judgments. So let me wrap this up by saying that if this kind of analysis suggests that alternatives to the formal justice system are likely to facilitate broad participation in the development process, then there's a good basis for considering ADR in the overall development strategy. And judgments on how to proceed, again, must reflect local conditions and knowledge and ownership. So summing up in my couple of minutes, development is a complex and a long-term process. Progress needs to be measured by reference to the impact on people. Those Millennium Development Goals are important, as are the agreed principles for effective partnership. Within that framework, support for the rule of law is an integral dimension of fostering good governance and inclusive economic growth. And these are the foundations of development, that are emphasized in the new U.S. Global Development Policy. Experience has confirmed the value of justice for development, but at the same time it has demonstrated the limitations of reliance entirely on formal justice institutions. So ADR holds promise for increasing the development effectiveness of justice systems and expanding opportunities for people. Now, there are enormous differences among countries. The needs, capacities, commitments, popular expectations, and external actors can only have imperfect knowledge of these differences and of the local history, social values, political sensitivities that underlie them. So I can't overemphasize the importance of local ownership and broad consultation and participation in the design of ADR informal dispute resolution into efforts to improve the administration of this. He and I go back to the 1980s when we were beginning some of this work, supporting it from the U.S. government, and we didn't know who are people who know about justice systems and developing countries, and who are people who speak Spanish and can talk about courts. And Bill was one of those people who was one of those rare people who had that set of skills, and I've been working with him since then. And I know that his insights and understanding will give a lot of valuable practical content to the question of what's been achieved and how rule of law can help. So I hope that this conceptual outline will be something that will be useful to set up his remarks, and I thank you for your attention, and look forward to hearing what Bill has to say about how to make it work. Well, it all waxes and wanes, and of course it's not only the U.S. government. One of the things that is interesting is you can now pick up materials from the Australian Aid Agency or Swiss Development Cooperation Agency, any number of international development organizations around the world. And the World Bank, I think, was the first among the multilateral, but now you see Bill and I worked on a rule of law program, the Asian Development Bank, we worked on the Inter-American Development Bank, and others. So it is broader, and it does wax and wane. As I said, we have the uncertainty right now of budget, austerity, fiscal pressures, not only in this country, but in Europe and Japan as well. And so we may see not only rule of law, but for all of development cooperation, I think we may see some hard times ahead. On the other hand, as I say, there are these other factors that are going, I think, will sustain this work. And that I don't think anybody's going to go back now and say rule of law is not relevant to development. That we can go back to simplistic approach. I think we are in an era where there's a recognition that this is a comprehensive effort.
What's your reaction on the local people in Latin America about the need pressing for rule of law?
Well, one of the things here Rebecca used the expression to the people vote with their feet. And we see this, I think you're going to talk about Casa de Justicia, I think Bill is probably going to touch on that as well, that we see in a number of countries where these multi-door courthouses that do informal as well as formal are attracting people who are using these systems, and people who previously had no expectation of access to justice. So I think we're seeing that these are very popular. The reactions are positive.
What about critics who would say that sometimes the public is just not ready for that? And I guess a couple responses to that might be that maybe one of the ways to make the public ready is to actually engage in those processes. But is there perhaps a point at which that even isn't possible?
Well, I don't believe in secrecy. I think that these things have their own dynamics in every society, and I get impatient when people say you have to have economic progress before you can have political reform, or people who say you have to have democracy before you can have economic progress. It depends so much on local circumstances. I do think that we can't get too narrow and think about dispute resolution processes as the subject matter, but we're talking the idea of saying, well, we'll wait till later.
Yeah, Brett?
One of your slides talks about holding governments accountable.
Yeah.
I know they thought this to be an ever-present concern. By mentioning it, do you have some new ideas as far as how you hold governments accountable for what's invested? Are they play a role in keeping them accountable?
I think I was referring to the 2004 definition of the rule of law that put together a characteristic of what rule of law is supposed to do. It's supposed to apply to the government, apply to the state, as well as to individuals and organizations within the state. I guess, I didn't have any particular thought-out notion of how ADR will be the instrument that holds government accountable, but I think a system of justice is supposed to have that aspiration of holding governments accountable, and does that through, among other things, transparent processes that allow people to see how.
Very good. We'll hold questions now. Bill, if you'll, again, thank you. I'm not a PowerPoint person, so I apologize. I'm from the old school, I guess. There's a lack of hand, right? There's a lack of hand. Okay, we can read that.
Can I read my, before I forget it.
In the paper which I did, I explained, well, first off, good morning, and thank you for the invitation. I apologize starting off in the middle of this presentation. I'm a neighbor. I grew up in Kentucky. Some of my background is I spent the better part of 30 years in the administration of justice in state and federal courts in the United States. I was the administrative director of the courts of Kentucky in 1975 to 79 when we eliminated 1,000 judges, 3,000 clerks, and rebuilt the entire trial court system from zero. Have passing acquaintance with some of the challenges of rule of law in this country. I was the administrative director of the courts of the state of California, and I was a circuit executive for the 9th Circuit in San Francisco. All of that interim between the time I was a Peace Corps volunteer in Chile in the 60s and deputy director of the Peace Corps in Chile. So my career experience starts that way, and then in the mid-'80s, as Jim correctly pointed out, I got a phone call from someone I didn't know, said they were looking for people who spoke Spanish and could talk justice issues in Latin America, and we heard that you did. So the next thing I know, I've spent 20 plus years consulting, starting in Latin America, but now in the Middle East, Central Asia, Africa, and part of Eastern Europe. So I come to this with a perspective of, if you will, a practitioner. I'm not, my focus has been on two concepts. I see them as integrated. It's not dissimilar to the presentation just made earlier. But everything we have tried to do has tried to build on the concepts of complementarity, and that is you want to support access to justice, and you want to support access to the justice systems. They are not the same, but they are entirely complementary. It seems to me every civilized society would prefer to have harmony, would prefer to have its citizenry self-reliant and able to resolve their own disputes. And they would prefer to have most of those disputes resolved independent of reliance upon the formal structures of government. There are a lot of reasons I don't think I have time to cover all that right now. But in so doing, I think you have a much more functional society. That's in fact what happens. More than, for example, we talk about litigation. The number of cases that go to court compared to the number of cases that are handled in administrative procedures is infinitesimal. The procedures are more than 10 times the number of cases that go to court. And yet we end up obsessing about the number of cases that are being litigated. And I use the word advising, obsessing. Let's take it for example. These numbers are the same in the United States, they're the same in federal, state, they're the same in almost 15 countries. Of civil cases filed, out of 100 filed, more than half disappear. They never prosper. They disappear. They go away for innumerable reasons. So when we start talking about what's happening in the system, you have to first talk about, well, what happened here with this group, and then what do we do with the balance that are before court? Now, we've done this. This isn't something I made up. We've done these studies in a lot of places. And what we find is that most cases that are filed disappear because people were angry, or they wanted leverage in a negotiation. They had some other motive. They never really intended to proceed. Or the alternative, they lost funds, something else occurred, and they could not proceed. So when you look at the distribution of resources, courts we can't have courthouses on every corner. Ultimately, if we have courthouses on every corner, no one will respect the law. It's like having who respects a traffic code? No one respects a traffic code. It's a supermarket. It's just like this. Courts need to be preserved for handling the most complex matters that cannot be handled by others. That's my view. The most valuable resource in the judicial system is the time of a judge. So if you think about it, where does that judge spend their time? How is it allocated? Because that's the only place a decision can be made. Nobody else has the authority to make a decision. So if you can expand the time of a judge to resolve cases, perhaps more of these will be decided as cases in trial, although I don't think the combat method is, in fact, the highest form of human development for resolving these problems. So when you look at access to justice and the justice systems, what you want to do is create access to justice through neighborhood centers, peer mediation programs, chambers of commerce, trade associations, and so forth. And so we've been involved in actually doing that, and I'm going to come to some examples. Complementary to that is access to justice systems, which is what Jim just drew on, is you want to make access to the justice system have as few hurdles as possible. Another, I think, I was really struck by the procedural justice discussion. In my experience, most of us have been doing this, think in terms of justice reform, and we're going to do it this way. What I heard the procedural justice discussion refer to is, I looked at it in this way. And that is from the perspective of the citizen. That the system responds to the needs of the citizen, not the inverse. Most of us lawyers all have this. We start from this. We start with structure, procedures, rules, courthouses, and somewhere down here is more citizens. And their interests may or may not have been considered in that process. So I think the wisdom of the procedural justice is it compels us to ask, what are we doing from the perspective of the citizen? So with that in mind, it's interesting, from this point, access to justice, we've just finished creating legal clinics at Al-Quds University in Jerusalem, where we've been working in the West Bank for about 10 years. We've just finished a series of intensive meetings with tribal leaders in 4 cities. Well, that's generous. 4 towns in the West Bank who control the traditional way of resolving conflict. And our strategy was to consult with them, and it took 6 months. This wasn't done in an afternoon. Encouraging them to understand that whatever process they engage their citizens in, that there were, in fact, international standards, i.e., most of the treatment of women. But there were other things that need to be considered, and that it would be in their best interest for the long term, if they wanted to create harmony in their society and foster development, that they be very aware of this. Well,
The outcome is they all signed a memorandum of understanding, the 4 tribal leaders, that they would adhere to a new set of principles, and that when disputes of a certain nature arose, they would take them to the formal justice system in Palestine. Well, it was a heavily participatory process. This was done, our staff is Palestinian, it's not U.S. based. The consultative process was the point at which we respected them enough to listen to them. We respected them enough that their views would be heard, but also we wanted to introduce them to the notion that traditional means aren't to be flash frozen for eternity. There's no reason for justifying continued discrimination against women. So there's no reason to have cultural relativity that we can't change things, that society do need to change. Well, I have a pretty dramatic slide. I didn't bring it today. The time is short. I don't want to get into that. So let me come back to the point of saying I see these 2 concepts as entirely complementary, and in our development work, we've tried to give life and expression to both of them. Access to justice systems, in an article we worked with Richard this summer on, in the Dispute Resolution magazine, there's an article about our experience in El Salvador, where more than 30 different centers were created. The most gratifying part was that we asked the people who were going to these centers what their perceptions of the process was. The most gratifying part was the highly affirmative response from the women who participated in the mediation process. If you're learning about Central America, in particular Salvador, you understand this is quite distinctive. And what they found is in the process their voice was heard, and they felt the non-adversarial nature of the process was much more acceptable to the way they wished to address conflict. I think the second point I'll draw on is the local legal culture. Whenever we do not carry a bag made in USA. So I probably have some challenges with some of my dear friends from the ABA. We do not export U.S. laws. I don't believe in that. Our strategy is to engage people. You know, when they asked Napoleon what his most successful military strategy was, he said, I engage the enemy and then I decide. Well, basically, that's my approach to development. You engage people. You consult them. You challenge their assumptions. And then you ask them, what options would they consider? And that's the method that we've used over the last 20 years. So some examples are things that we might not have thought about. In an ADR program we've had in Jordan, we were surprised to find that the most significant part of the process to the participants was the role apology had in resolving disputes. That may be participation, but for them, it was apology. There was a moment at which point the parties acknowledged they had done some harm to another person. That was more important than anything else. Well, that's not something that we necessarily foreseen. In 1992, with the funds of AID, we started a process in Latin America with the first, as far as I know, the first conference for the whole hemisphere on ADR in Buenos Aires. The intention was to create in each country of Latin America a nucleus of people who knew about ADR and who in turn would carry out and execute programs of dispute resolution in that country, their country. Well, every country today in Latin America has a very active group of professionals with expertise in dispute resolution. Many of whom have come to study in the United States, some have gone to Europe, but many have actually studied in Latin America. Today in Latin America, certainly Argentina, Colombia, to name the most prominent ones, but all of the other countries have dispute resolution programs annexed to the courts, and many have actually worked extensively on creating informal systems. There was, I would say easily there's 5,000 plus people involved in Latin American dispute resolution. It is not an American export. You cannot control ideas. We don't own these ideas. They move. They move just like water seeks a level. And what you see now in Latin America is an entirely Latin American notion this week, the Institute for the Studies of Justice in the Americas is having its own reflection on lessons learned in Latin America in implementing dispute resolution. Americans aren't involved. So I think the point I want to make here is that this transition has already occurred. The ownership belongs in Latin America. It is theirs. They are adapting it to their own way of seeing things. I would also observe that it's my experience that legal systems evolve organically. I've not been partial to the belief that you can actually put a chip in and take something and have it result in the kind of change that you would expect. So what you have to think of, at least how we've approached this, is you approach it by respecting the other party, respecting their culture and their system, and finding points of common understanding around which they in turn can take the initiative and make whatever change they think is appropriate. One of the things that we've introduced, which has been very effective, is we call it the Q10. It's a questionnaire, so we take a questionnaire every 90 days in our projects and constantly interview the users of the system. So we're constantly creating a feedback mechanism on what the people are thinking about what's transpiring in their engagement around dispute resolution. It has a dual process. It tells us what's being taught, but it also reinforces the notion that the citizen has a voice in speaking about what's happening to them. And that's an indirect way of educating the people with whom we're working on how they can make because once this project ends, it's theirs, they own it. So we want to leave that country, wherever that happens to be, with a discipline having been developed around this experience. You know, it's stressful being a Southerner and having to talk fast. So I apologize. I had some other things, but I'd like to stop because I love to have the interaction more than the presentation. So if there's time, please, I'd be glad. Lamentations, observations, distress, whatever, I'd be glad to entertain all those. I'm not stressed by that.
Yeah.
Yes. I don't separate them. I think both things go together. I think in the El Salvador experience, as I cited, the legitimacy of the judicial system was enhanced, particularly in the eyes of women, because the system actually created a forum which was far more amenable to them than the formal forum was to resolving difficulties. Jay knows in California in 1982 or 3, they created the Family Court Services for resolving divorce disputes in California. And we did a lot of research on that. And the same results came back. Particularly from a women's perspective, the mediation process was far more acceptable than having to go through a hors de combat formal courtroom. So my experience has been it's been far more adaptable. So for example, the other point I should have suggested, we try to find, and I've found no exception, every culture I've ever worked in, there are historical means of resolving conflict through traditional means. They may be moribund right now. In fact, that's not uncommon. But if you can find and respect those traditions, you can actually build a bridge to understand what you're talking about is building on something that existed previously. It may have fallen into disrepute for innumerable reasons, but there may be ways to resurrect it. So my focus is to try to find something that builds up the self-esteem and the mobility of the people with whom I'm working, and they want and the way they want it and how it looks according to their own design.
Question? Yeah.
In your diagram, you said you like to take to approach the citizen's perception of fairness and the legal system. And you illustrate that with focus groups,
Right.
what have you.
Right.
And it seems like you're engaging in consensus building.
Right.
However, with focus groups can represent the general population. So how do you take those focus groups to try to represent what the general population is to do as fair?
Well, you can't involve everybody to do everything. It's impossible. You have to take people who are in a position of responsibility. You have to encourage them. I use the infallible rule of 1/3. Every group, in my experience, divides into 1/3. 1/3 never met a new idea they like. They're nice people. You can have coffee with them, but they're not going to lead anything. They won't even lead a silent prayer. 1/3 are from the I don't know, could be, maybe, and 1/3 say yes. So you have to find the people who say yes because they lead things. And then you create a dynamic with the 1/3 who lead and 1/3 who are in the middle, and that's all you can ever expect. You can't consult with the whole country. That's impossible. But it's their country, so what you're doing is trying to create a dynamic where they are in the position to exercise the leadership because they both are informed, they make an informed judgment, they consult with people. Go on, regrettably, the problem is having a lot of experience with a lot of examples. We've got 10,000 people involved in the Dominican Republic in a whole consultative process around building integrity as an antidote to corruption. Most people think about corruption as a list of don'ts. What's the antidote to corruption is integrity. So how do you build integrity? Well, in fact, you have elaborate structures of highly engaged processes of consultation among others.
Yeah.
You mentioned how Latin Americans take an ADR and they've made it their own.
Yeah.
They define that it's different than how we do things here. And I was wondering how specifically might it be different? What do they do? And is there anything we can learn from how they change things, what they do?
Well, there are 20 countries. There's an enormous variant. It's hard to generalize. And within countries, there are regional and cultural variants. So you can see, for example, in one real sense, the houses of justice concept that Frank Sanders wrote about years ago has been adapted and modified, and certainly in Colombia there are examples. In Central America, there's in Guatemala and El Salvador. There are variants on it in Argentina. And what I would say is they embraced it more fully than we did. And in fact, have applied it more aggressively than we did. And of course, their needs are different because they did not have a strong institutional framework. I would say that that's a right area for investigation and doing comparative work. Because it has not prospered in our country in the way it was envisioned. It's not something that's uniformly found across the country. But you can see whole countries embracing the concept because it puts in a single place, a place where the citizenry can go and try to get attention for public services because that's part of the House of Justice, but also resolution because that's possible of conflict. I would say that's certainly one of the examples.
Phil, I want to ask you, in all of your work that you've done across the world, is there anything that we do here that really just doesn't fly elsewhere, or didn't fly in particular?
Well, early neutral evaluation, something that I worked on way back in the early 80s when I was a circuit executive. It's too strange to people. It's way too strange. They can't understand that. The idea that you would take a case and you would go down the hall and some person would listen to you and say this and that. Let me come back to the comment you made about trust. The absence of trust, which is ubiquitous, it's everywhere you go. It's primarily the most dominant thing you find. Limits the ability of third-party neutrals to have an active role in the process. Because nobody assumes anybody's neutral. There are no neutrals. Everybody belongs to a political movement. So so if you say, oh, let's go down the hall to Richard, he's a neutral, he will evaluate your case and give you an opinion. That's very hard for lawyers to believe.
It's really more a common question, but something I was really struck when we worked in Africa by the extent to which traditional justice systems, not always perfect, but in principle, are focused on relationships between parties, which are likely to be continuing relationships. But these systems were built up in small communities where after the dispute is over, the neighbors have to live next to each other. And so it's less of a win or lose mentality that is rather strong in our system. You have disputes, you litigate, somebody wins, somebody loses, walk of life. And I think those cultural differences factor into the ability to communicate sometimes between people who are oriented in these different values.
In the history in Central America, there's a history of a figure called the amigable componidor, which is actually the friendly putter together. That's what it translates loosely. And it's a historic figure of a person who has standing by virtue of their reputation in the community. So people took their disputes to this figure, and it's almost always a man, would decide, and who may have mediated or he may have decided. Why was I was using that to say, sorry? Right. That's the only place I could find something similar, because my strategy is always find something within the context that is proximate to what we're talking about. It makes it easier to understand, and then they can relate and try to adjust it. I have tried to cultivate an eye that looks for points of similarity and concurrence, not points of disagreement. And in that way, you can build understanding and trust much faster.
Well, if there's going to be any trust in me, I think we need to go ahead and take our break now. So thank you very much, Joe.